Hello, everybody, and welcome to History/Law Bite number 336, dated January 2nd, 2022. I'm Walter, your mobile historian and blue-collar scholar. Thank you so much for tuning in today. This History/Law Bite is entitled McCleskey versus Kemp, 481 U.S. 279, 1987. Before I begin, however, I'd like to formally invite you to subscribe to my YouTube channel, Juarez Lee Shelton, M.A. And in addition to that, please also click on the little notification bell immediately to the right of the subscribe button. In doing so, you will receive notifications when I post new, exciting, and enlightening videos in history, law, political science, theology, and philosophy. Thank you so much in advance. You're the best. So again, this History/Law Bite is entitled McCleskey versus Kemp, 1987. Now, if you've never heard of this Supreme Court decision, McCleskey v. Kemp was a very, very significant case in U.S. constitutional law that focused on the subject of capital punishment and the applicability of studies and evidence showing racial disparities in its application. Thus, we begin the same way the U.S. Supreme Court does. All rise. The Honorable, the Chief Justice and the Associate Justices of the Supreme Court of the United States. Oyez, oyez, oyez. All persons having business before the Honorable, the Supreme Court of the United States, are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Please be seated. We will now hear argument in number 84, 6811, Warren McCleskey versus Ralph Kemp. Mr. Chief Justice, and may it please the court. We now divulge into the facts of McCleskey versus Kemp. So petitioner Warren McCleskey was an African-American man convicted of 2 counts of armed robbery and 1 count of murder in Fulton County, Georgia. The murder count was for the killing of a white victim, Atlanta police officer Frank Schlatt. After being convicted and at the sentencing phase, the jury in McCleskey's case concluded that 2 aggravating circumstances had occurred beyond reasonable doubt. The first was the murder of Officer Schlatt had in fact took place during the course of a robbery. So the first instance was that the murder of Officer Schlatt took place during the course of a robbery, and the second was that the murder was of a policeman in the performance of his duties. In Georgia, the finding of either of these circumstances to be aggravated was sufficient for the imposition of a death sentence. Because the petitioner offered no mitigating circumstances, the jury in his case recommended death, and the court accordingly sentenced Mr. McCleskey to death. Accordingly, the death sentence was affirmed by the Supreme Court of Georgia. Seeking to raise a constitutional issue over alleged racial bias in the sentence, petitioner's attorneys took the case into the federal courts via a habeas corpus petition. In the United States District Court for the Northern District of Georgia, attorneys for petitioner argued that Georgia's capital sentencing scheme was applied in a racially discriminatory fashion prohibited by the 8th and 14th Amendments to the United States Constitution. They defended these assertions with statistical evidence from what was known as the Baldus study, named for Professor David C. Baldus at the University of Iowa. The study, which was very data comprehensive, argued that racial considerations entered into capital sentencing decisions. To touch a little bit on the Baldus study, he did a comprehensive analysis of some 2,500 murder cases in the state of Georgia. The study found that individuals of all races were substantially more likely to receive death sentences for killing white victims. Also, defendants were 4.3 times more likely to receive death sentences for killing white victims as opposed to black victims. Ultimately, the district court rejected the constitutional claims and the petition largely because it was based on the Baldus study itself, and that none of these claims, no factual evidence of discrimination had occurred to Mr. McCleskey himself, regardless of these statistics. Okay, and the 11th Circuit Court of Appeals affirmed the district court's holding, right? Again, because even though the evidence presented in the study was compelling and certainly legitimate, no particular instances of discrimination had been shown to have been, displayed to Mr. McCleskey during the course of his trial and sentencing. Okay, so the 11th Circuit assumed the validity of the Baldus study, but found the statistics insufficient to demonstrate unconstitutional discrimination in the 14th Amendment context, or to show irrationality, arbitrariness, and capriciousness under 8th Amendment analysis. Therefore, it was not sufficient cause or evidence to overturn the defendant's death sentence. Petitioners then appealed to the Supreme Court of the United States. At oral argument on October 15th, 1986, attorneys for petitioner argued that Georgia's capital sentencing system as applied was in violation of both the 8th and 14th Amendments to the U.S. Constitution. They presented the evidence contained in the Baldus study as statistical proof of the racial disparities contained in Georgia's system, and argued that it violated the standards of cruel and unusual punishment, due process, and equal protection of the laws. Therefore, the petitioner's death sentence should be overturned. On the other side of the lectern, attorneys for respondent Kemp argued that Georgia's capital sentencing scheme was not in violation of the Constitution. While racial disparities may indeed exist, such things may be expected in any system, and the process for which Georgia allowed capital punishment were fully in accord with the 8th and 14th Amendments to the Constitution. Indeed, the statistics in the Baldus study did not reflect unconstitutional discrimination in the 14th Amendment context, or to show irrationality, arbitrariness, and capriciousness under the 8th Amendment. The petitioner's death sentence was therefore given according to law and should not be reversed. So the issues facing the Supreme Court of the United States in this case were as follows. Did Georgia's capital sentencing scheme as applied violate the 8th and 14th Amendments to the Constitution as suggested by the Baldus study? And if so, should the petitioner's death sentence be reversed? To the opinion of the court, the answer to those questions were both no and no. On April 23, 1987, in a 5-4 opinion authored by Justice Lewis Powell, the Supreme Court affirmed the 11th Circuit Court of Appeals and affirmed the constitutionality of McCleskey's death sentence. Powell's opinion concluded that the presentation of evidence showing racial disparities in the application of death sentences was not sufficient cause to overturn McCleskey's, per se. That was because there was no demonstrable, purposeful discrimination against McCleskey, which had a discriminatory effect on him in his own trial. Therefore, no constitutional violation existed. Justice Powell's majority opinion was joined in full by Chief Justice William Rehnquist and Justices Byron White, Sandra Day O'Connor, and Antonin Scalia. Justice William J. Brennan Jr. filed a dissenting opinion that was joined by Justices Thurgood Marshall, Harry Blackmun, and John Paul Stevens, in part. Justice Harry Blackmun filed a dissenting opinion joined by Justice Brennan, in part, as well as Justices Marshall and Stevens. Justice Stevens filed a dissenting opinion joined by Justice Blackmun. So now we move to a summary of the opinion, your cheat sheet, your cliff notes, if you will. The summary of the opinion in McCleskey versus Kemp, ladies and gentlemen. It is as follows. The existence of statistical evidence showing racial disparities in Georgia's death sentencing scheme was not sufficient to overturn the petitioner's death sentence. This was because no specific purposeful discrimination was shown against petitioner which had a discriminatory effect on him in his own trial. Therefore, no constitutional violation existed. So now we move on to Justice Powell's opinion and the most relevant points contained therein. Number one, the Baldus study does not establish that the administration of the Georgia capital punishment system violates the Equal Protection Clause. A. To prevail under that clause, petitioner must prove that the decision makers in his case acted with discriminatory purpose. Petitioner offered no specific evidence to his own case that would support an inference that racial considerations played a part in his sentence, and that the Baldus study is insufficient to support an inference that any of the decision makers in his case acted with discriminatory purpose. This court has accepted statistics as proof of intent to discriminate in the context of a state's selection of the jury veneer and in the context of statutory violations under Title VII of the Civil Rights Act of 1964. However, the nature of the capital sentencing decision and the relationship of the statistics to that decision are fundamentally different from the corresponding elements in the veneer selection or Title VII cases. Petitioner's statistical proffer must be viewed in the context of his challenge to decisions at the heart of the state's criminal justice system. Because discretion is essential to the criminal justice process, exceptionally clear proof is required before this court will infer that discretion has been abused. B. There is no merit to petitioner's argument that the Baldus study proves that the state has violated the Equal Protection Clause by adopting the capital punishment statute and allowing it to remain in force despite its allegedly discriminatory application. For this point to prevail, petitioner would have to prove that the Georgia legislature enacted or maintained the death penalty because of an anticipated racially discriminatory effect. There is no evidence that the legislature either enacted the statute to further a racially discriminatory purpose or maintained the statute because of the racially disproportionate impact suggested by the Baldus study. Number two, petitioner's argument that the Baldus study demonstrates that the Georgia capital sentencing system violates the Eighth Amendment's prohibition of cruel and unusual punishment must be analyzed in the light of this court's prior decisions under that amendment. Decisions since Furman v. Georgia, 1972, have identified a constitutionally permissible range of discretion in imposing the death penalty. First, there is a required threshold below which the death penalty cannot be imposed, and the state must establish rational criteria that narrow the decision maker's discretion as to whether the circumstances of a particular defendant's case meet that threshold. Second, states cannot limit the sentencer's consideration of any relevant circumstance that could cause it to decline to impose the death penalty. In this respect, the state cannot channel the sentence's discretion, but must allow it to consider any relevant information offered by the defendant. Number three, the Baldus study does not demonstrate that the Georgia capital sentencing system violates the Eighth Amendment. A. Petitioner cannot successfully argue that the sentence in his case is disproportionate to the sentences in other murder cases. On one hand, he cannot base a constitutional claim on an argument that his case differs from other cases in which defendants did receive the death penalty. The Georgia Supreme Court found that his death sentence was not disproportionate to other death sentences imposed in the state. On the other hand, absent a showing that the Georgia capital punishment system operates in an arbitrary and capricious manner, petitioner cannot prove a constitutional violation by demonstrating that other defendants who may be similarly situated did not receive the death penalty. The opportunities for discretionary leniency under state law do not render the capital sentences imposed arbitrary, and capricious. Because petitioner's sentence was imposed under Georgia's sentencing procedures that focused discretion on the particularized nature of the crime and the particularized characteristics of the individual defendant, it may be presumed that his death sentence was not wantonly and freakishly imposed, and thus that the sentence is not disproportionate with any recognized meaning under the Eighth Amendment. There is no merit to the contention that the Baldus study shows that Georgia's capital punishment system is arbitrary and capricious in application. The statistics do not prove that race enters into any capital sentencing decisions or that race was a factor in petitioner's case. The likelihood of racial prejudice allegedly shown by the study does not constitute the constitutional measure of an acceptable risk of racial prejudice. The inherent lack of predictability of jury decisions does not justify their condemnation. On the contrary, it is the jury's function to make the difficult and uniquely human judgments that defy codification and that build discretion, equity, and flexibility into the legal system. At most, the Baldus study indicates a discrepancy that appears to correlate with race, but this discrepancy does not constitute a major systemic defect. Any mode for determining guilt or punishment has its weaknesses and the potential for misuse. Despite such imperfections, constitutional guarantees are met when the mode for determining guilt or punishment has been surrounded with safeguards to make it as fair as possible. Petitioner's claim, taken to its logical conclusion, throws into serious question the principles that underlie the entire criminal justice system. His claim easily could be extended to apply to other types of penalties and to claims based on unexplained discrepancies, correlating to membership in other minority groups and even to gender. The Constitution does not require that a state eliminate any demonstrable disparity that correlates with a potentially irrelevant factor in order to operate a criminal justice system that includes capital punishment. Petitioner's arguments are best presented to the legislative bodies, not the courts. All right? So that is an overview of the major points contained in Justice Lewis Powell's majority opinion. We now move to the dissent by Justice William J. Brennan, Jr., who was joined in his dissent by Justice Marshall, as well as Justice Blackmun and Justice Stevens. Justice Brennan wrote, "Adhering to my view that the death penalty is in all circumstances cruel and unusual punishment, forbidden by the 8th and 14th Amendments, I would vacate the decision below insofar as it left undisturbed the death sentence imposed in this case." The court observes that the Gregg-type statute imposed here gives unprecedented safeguards in the special context of capital punishment, which ensure a degree of care in the imposition of the death penalty that can be described only as unique. Notwithstanding these efforts, murder defendants in Georgia with white victims are more than 4 times likely to receive the death sentence as are defendants with black victims. Petitioners exhibit DB 82. Nothing could convey more powerfully the intractable reality of the death penalty. That the effort to eliminate arbitrariness in the infliction of that ultimate sanction is so plainly doomed to failure that it and the death penalty must be abandoned altogether. Quoting Justice Thurgood Marshall in Godfrey v. Georgia, 1980. Even if I did not hold this position, however, I would reverse the Court of Appeals. For Petitioner McCleskey has clearly demonstrated that his death sentence was imposed in violation of the 8th and 14th Amendments. While I joined parts 1 through 4A of Justice Blackmun's dissenting opinion discussing Petitioner's 14th Amendment claim, I write separately to emphasize how conclusively McCleskey has also demonstrated precisely the type of risk of irrationality in sentencing that we have consistently condemned in our 8th Amendment jurisprudence. So that's Justice Brennan's dissenting opinion. Next, Justice Blackmun's dissenting opinion. He was joined in his dissent by Justice Marshall, as well as Justice Stevens and Justice Brennan to a significant extent. Justice Blackmun wrote, among other things, that the court today sanctions the execution of a man despite his presentation of evidence that established a constitutionally intolerable level of racially based discrimination leading to the imposition of his death sentence. I am disappointed with the court's action, not only because of its denial of constitutional guarantees to Petitioner McCleskey individually, but also because of its departure from what seems to me to be well-developed constitutional jurisprudence. Justice Brennan has thoroughly demonstrated that if one assumes that the statistical evidence presented by Petitioner McCleskey is valid, as we must in light of the Court of Appeals assumption, there exists in the Georgia capital sentencing scheme a risk of racially based discrimination that is so acute that it violates the Eighth Amendment. His analysis of McCleskey's case in terms of the Eighth Amendment is consistent with this court's recognition that because capital cases involve the state's imposition of a punishment that is unique both in kind and degree, the decision in such cases must reflect a heightened degree of reliability under the amendment's prohibition of the infliction of cruel and unusual punishments. Right? I therefore join parts 2 through 5 of Justice Brennan's dissenting opinion. So that takes us now to Justice Stevens' dissenting opinion. Stevens' dissent was joined by Justice Blackmun alone. He wrote, "There is a qualitative difference between death and any other permissible form of punishment, and hence a corresponding difference in the need for reliability in the determination that death is the appropriate punishment in a specific case. The court's decision appears to be based on a fear that the acceptance of McCleskey's claim would sound the death knell for capital punishment in Georgia. If society were indeed forced to choose between a racially discriminatory death penalty, one that provides heightened protection against murder for whites only, and no death penalty at all, the choice mandated by the Constitution would be plain. But the court's fear is unfounded. Like Justice Brennan, I would therefore reverse the judgment of the Court of Appeals. I believe, however, that further proceedings are necessary in order to determine whether McCleskey's death sentence should be set aside. First, the Court of Appeals must decide whether the Baldus study is valid. I am persuaded that it is. But orderly procedure requires that the Court of Appeals address this issue before we actually decide the question. Second, it is necessary for the district court to determine whether the particular facts of McCleskey's crime and his background place this case within the range of cases that present an unacceptable risk that race played a decisive role in McCleskey's sentencing. Accordingly, I respectfully dissent. So the judgment of the court in this case, the 11th Circuit Court of Appeals, was affirmed. The laws applied here, Amendments 8 and 14 of the United States Constitution. So we now move on to the legacy of McCleskey versus Kemp. McCleskey v. Kemp, needless to say, is widely regarded as one of the Supreme Court's worst decisions since World War II. Because of its language and effective shielding of institutionalized racism in the capital sentencing process, it is viewed by many legal scholars as one of the court's Dred Scotts. That unflattering term is given to select Supreme Court decisions which give legal blessing to one or more forms of blatant injustice. To quote Professor Michelle Alexander, the decision instituted an insurmountable standard in challenging racism in the criminal justice process. Outside of intentional discrimination, conscious, deliberate bias, which is next to impossible to prove. The effect has been to immunize the criminal justice system from the racial disparities that go unchecked every day by our courts and legal process. And she hit the nail on the head, with that. That is very, very true. McCleskey has, more or less erected an electrified fence around, the ability to challenge, racism in the criminal justice process, unless you can prove that there was intentional discrimination, all right, which is virtually impossible unless one of the players in it all admits it. And who's going to do that? Exactly. Ironically, the decision's author, the late Justice Lewis Powell, had buyer's remorse very quickly after this decision. He publicly stated that if there was any case he would change his vote in, he stated it would be McCleskey versus Kemp. When he was interviewed in 1991 for biographical purposes, he was asked that question. He actually also gave another case, Bowers versus Hardwick as well. But he definitely said McCleskey versus Kemp. Okay. This is in 1991, 4 years after he retired from the Supreme Court. Okay. Powell's views on capital punishment had evolved substantially since his retirement from the court. And he had come to criticize the way states were unable to carry out their capital sentencing process in a fair and constitutional manner, bringing discredit on the whole system. Thus, his evolved position on McCleskey was consistent with his changed view on the administration of capital punishment. So for the record, our petitioner here in this case, Mr. Warren McCleskey, as a result of this decision, would be executed by way of electrocution on September 25th, 1991. All right. He was 46 years old. Lastly, in this case, Justice Thurgood Marshall was the only member of the Supreme Court at this time who had any real-world experience in dealing with the Southern criminal justice systems. In his many years as a lawyer, he had represented a litany of black clients against criminal charges before Southern judges and juries, all right? Some successfully and some not, all right? He didn't win every single case he litigated, but he sure gave it his all in each and every one he did, risking his own life and limb quite often to represent these defendants in the South. Not exactly a black man friendly place in the 1930s and 40s and 50s. Okay. The irony here is that it is beyond question that this case resonated with Justice Marshall more than any other member of the court. He knew firsthand the blatant racism that existed in the justice systems in the Southern states. All right. And it wasn't subtle racism either. All right. Like I said, Marshall often had his own life threatened by, local officials in those Southern states for representing black defendants. So he knew this firsthand. All right. And, of the 4 dissenters, he was the only one who did not express his views in writing, which is very strange, but nonetheless, he did not do so. He dissented in silence. But arguably, had he written a dissent, it would have had more meaning and effect than any of the others, because Thurgood Marshall knew this firsthand. He knew firsthand the racism that existed in the American South, and these disparities that showed up in the Baldus study for him were not just mere statistics. This was a reality that he himself had lived. All right. So while the other dissenters were just going based on what they've read and heard, Marshall would have actually lived it and had lived it. All right. And would have undoubtedly put a lot of that experience in the language of his dissent. Okay. So that concludes our video on McCleskey versus Kemp. And I'll give you the summary of the opinion one more time before I let you go. And that is that the existence of statistical evidence showing racial disparities in Georgia's death sentencing scheme was not sufficient to overturn the petitioner's death sentence. This was because no specific purposeful discrimination had been shown against the petitioner, which had a discriminatory effect on him in his own trial. Therefore, no constitutional violation existed. Okay? So that is summary of the opinion of the court in McCleskey versus Kemp, 481 U.S. 279, 1987. All right? And this case effectively placed the entire burden of proof on the petitioner here to show that they themselves, in their case, were victims of discrimination, and that the power players in their cases, judges, juries, local officials, all right, had acted with intentional discrimination, all right? And thus that standard has placed a very high wall, okay, in front of anyone seeking to challenge institutionalized racism in the criminal justice system. Okay, because of this decision, the petitioner has to prove intentional discrimination on the part of the powers that be. All right, the system, the judges, the lawyers, all right, the jury. All right, judges, prosecutors, jury, all of that. The petitioner would have to prove the discrimination was intentional from them, all right, in order to successfully prevail against them in a suit alleging racial bias. So that concludes this video. Just wanted to make sure you got the full gist of all of it. I hope you enjoyed it. Hope you learned a thing or two from it. If you did, and you definitely like what you have absorbed through these 30 plus minutes, if you made it that far, congratulations. Drop me a like. It would greatly be appreciated. And if you've not subscribed to my YouTube channel at this point, please do so now. Again, Juarez Lee Shelton, M.A. So I thank you so much for listening. And I conclude with with the words of one of my teaching role models, Mr. George Feeney. Believe in yourself, dream, try, do good. And with my own words, take care of yourself, stay safe out there, and be blessed. And I'll talk to you at the next video. Cheers.